Good afternoon, everybody. I'm going to turn the mic over to our friend Joanne DiPietro. Before I do that, I just wanted to thank the folks from Charwell House for sponsoring the refreshments from today. You know, they're really good. Okay, thank you. Today we're going to talk about the purpose of the probate court, and here is Joanne. Okay.
Good afternoon, everyone. How's everyone doing? My name is Joanne DiPietro. As you know, I'm an attorney in town. This year is my 25th year practicing law. Thanks for coming today. We do have handouts here for anyone that came in a little bit late. As I always have to tell you, if you have any questions, we're more than welcome to answer them for you. But this is for informational purposes only, and you should be speaking with your own professionals, whether it's a CPA or an attorney. So today we have special guests with us, which I'm very appreciative that they came today, because you can listen to me talk about this stuff, but you're going to hear the fundamentals of it, how the procedures within the courts work. These are the people that we rely on in our office to make sure our files are moving along properly, and also to get our clients where they need to be to meet their goals, whether it's having to sell a home or whatever it might be. So today we have the Register of the Norfolk Division of the Probate Court, Colleen Brierley, with us. Colleen was practicing law for 25 years. Over that, prior to becoming the Register of the Probate Court. And then her first, I wrote it down, sorry. First Assistant Registrar and Magistrate, Michael Barbadoro, is here as well. Michael was actually in the probate court for 11 years prior to becoming an attorney. He practiced for 3 years, and then he went back to the court. And I can tell you, during all of my years of practicing law, Michael has been instrumental to helping attorneys and anybody that comes into the court that needs help to make sure the files are moving along appropriately. So let's just recap a little bit on probate. And one of the things that we talk about when you do your estate plan is created so that you appoint fiduciaries. Fiduciaries are the people that speak for you. And when you appoint those people, they're going to speak for you, whether it's because you've lost your marble, you have incapacity, or you've passed. Now, if there's two ways, if you die without a will or you die with a will. In both instances, we have to go to the probate court to make sure the functionality of the estate is settled. In the probate court, what they want to make sure is all the heirs at law get what they're supposed to get. So I am going to turn it over to the professionals now. What we usually do, as you know, is if there's any questions, please feel free to ask. I do have to come to you with the microphone, so just be patient with me on that. But remember, someone else sitting next to you may have a question as well, and they may not necessarily know how to articulate it. So please feel free to raise your hand, and I'll give you the mic. Thank you.
Thank you. Hello, everybody. Hello, can you hear me okay? Yes, I'm so happy to be here. It's nice to be out of the courthouse. We're on a field trip today. I grew up in, what's that? I'm sorry? It's sunny out. I just heard on the way here that it's going to rain again, but that's all right. It's not snow, right? Yeah. So I'm Colleen Brierley, and I grew up in Norwood, right next door. Are you all from Walpole? Yeah. Our football rivals? Yeah. Now you're from here, yeah. Anybody from Norwood? Oh, hi guys. Is everybody from Norfolk County? Norfolk County has 28 cities and towns. Yes, so it's very nice to see and meet you all. Before becoming the Register of Probate, I took office right in the middle of the pandemic, and the world was shut down, as we all know, and before that, I had been practicing in Plymouth County a lot, in Norfolk County, doing a lot of juvenile court work, and also probate work. And so I really specialized in guardianships. And I'm going to leave it to Mike to talk about some of the nuts and bolts of that. But I want to explain to you, I think a lot of people don't know what the Register of Probate does. Does anybody here have questions about that? It's kind of a different job in that what we do is we process and we keep the records. And in Norfolk County, our Norfolk County registry goes back to the year 1793. And I actually have in my office the original wills of the Adams family members and also John Hancock, right? And that's for my safekeeping, that I need to make sure that those records are safe and are preserved forevermore, but also each and every one of your documents as well. So that is really my primary function. I take it very seriously. I'm very honored to be your Register of Probate. So as was mentioned earlier, when people come to the Probate and Family Court, they're often in crisis. We do deal with probate matters, but also we have a wide array of subject matter that we deal with there. Anything from a change of name, a divorce, guardianships, conservatorships. We deal with DCF cases when families are struggling, members have mental health issues and they need to get a guardianship for kids before they're taken into foster care. So these are all things that we do there. But today we're going to talk about the probate matters. And do a lot of you have wills already? Yep. So when you have a will, that really is you taking control in determining who is going to receive your property, your probate property, when you pass away. But a lot of people don't have wills, and their family members come to us after that to file different paperwork in order to, it's a different process, in order to, the law will determine under intestate laws who receives that property. So I'm going to give it to Mike right now, and then I'll come back on to answer some questions. But here you go. This is Mike Barbadoro. He's my first assistant register. He's an attorney as well, and he is my right arm. There you go.
How you doing, folks? Nice to see you. I guess some basic nuts and bolts that I can touch base on, and we put it out on that handout for you to just so you have it in black and white. I don't think the sheet is actually black and white, but the print's black. But there's some basic definitions almost, or just blurbs to describe certain things that people hear about. People hear these terms a lot. They hear probate and probate property. You hear guardianship. You hear conservatorship. What are these things? These are subject matters that we deal with, and in a lot of instances they're appointments. But so to start off with really what the flyer kind of dictates, the probate property is just what we put in the handout there. Probate property is property that's solely in your name. Now, as Joanne had mentioned, you always want to make sure that you're touching base with your attorney that's assisting you with your estate plans to make sure that, we usually say as practitioners, every 5 to 10 years or so, you want to look and touch base with your estate planning attorney to make sure that your estate plan is functioning the way you want it to function. And we say 5 to 10 years because things change quickly. Whether it's you're approaching at retirement age. I have a very different estate plan right now as a married gentleman with a very young child than my estate plan will look like when I'm approaching retirement. Yes, yes. But in any event, the process of probating the wills is just as we said in the handout. It's probate properties, property that's left solely in a person's name at the time that they pass away. So that's property that's not jointly held or that already has beneficiary designations. And this is why estate planning is so important, is because people do a lot of estate planning to sometimes avoid probate, so that there are no questions, so things kind of pass by the operation of the documents or operation of law, rather than having the probate court get involved. But when we do get involved, we handle primarily probate property when it comes to somebody's property when they're passing. Probate property, again, is property that is held solely in a person's name only. No, not joint property, solely in the person's name only at the time of their passing. And if you have a will, we will probate the will. The will is not valid until it's actually probated by the probate court. We give it its blessing. And we don't do that until we give notice to all beneficiaries under the will and all heirs. And the heirs are people who take property when there is no will. That's what the intestate laws, the intestate statutes say who is to inherit. And that depends on what the family dynamic is, whether there's a surviving spouse, whether there is children, whether there are children that are or are not the children of the surviving spouse. These are all differences. And this is why creating a will can be so important, because you want to make sure that your property is going where you want it to go. The other two very quick topics that we put on there is guardianship and conservatorship. People hear these terms a lot, and they don't know what they necessarily are. And they're very similar, but they do different things. A guardian is a person who speaks for you, as Joanne did. It's a type of fiduciary that speaks for you, that can help you in either some or all areas of decision making when it comes to your health, welfare, or care. Yes.
Explain what a fiduciary is.
Yes, yes. Absolutely, and yes, and a fiduciary. There is many different types of fiduciaries, but a fiduciary is basically, like Joanne says, a person that speaks for you. A fiduciary can be a trustee. A fiduciary can be a personal representative under an estate. A fiduciary is a guardian. A fiduciary is a conservator. But the idea is that their appointments come with what we call fiduciary duties. They come with powers and duties, and those duties are numerous, and the powers are numerous. But in all instances, they're required to act on your best interest. That is the basic idea: is acting on a fiduciary acts on the behalf of and for the benefit of another. We do these appointments when somebody loses. A guardian is for the purpose of general welfare, care, maintenance. A conservator is appointed in the same fashion, but they do that to handle business affairs. If somebody needs help due to a clinically diagnosed condition, needs help making some decisions in all or some areas, these appointments can be limited. But the process is you file this paperwork. This paperwork is petitioned to the court. It's filed with us. We issue what we call citations to give notice to on all interested persons, family members, so that they're notified. So that they're notified and that they can come back and report to the court if they have a concern. If there's a concern about the person that's asking to be appointed, whether that person may be, for whatever reason, that other interested person that receives notice, say this person is not the best person most suited to serve in this role, to serve in this capacity. They might not have the person's best interest at heart. They might have a competing interest that causes a concern. So these are all things that we vet out in the probate court through these types of proceedings, through petitions, giving notice to people, and having an opportunity to be heard.
Notice to charities.
Notice to charities, absolutely, absolutely. So
Anybody that might have an interest in that estate.
yes, correct. So that's some of the processes that we deal with quite often. But I will turn it back over to the register just to, we wanted to hit some of these. But yes, you have a question.
Yeah, talking about the guardianship and the,
Conservatorship.
thank you.
Yes.
We don't need that if we're married and if something happened to me, my husband would be able to step into that, or do we need that type of stuff?
So that's an excellent question, and that's one of the things that Joanne, I think, wants to talk about a little bit, is that is all involved and resolved through your estate plan, through what we call powers of attorney. There's documents that operate outside of the court, and they're done for a lot of different reasons, but one of the reasons is to avoid probate, to avoid probate court. The best example that I can give is that I give quite often. Yes, a healthcare proxy. If somebody gets injured, if you and your spouse is driving along in a car and one of you is fine in an accident, but the other one is injured, not to the point where they're deceased, but they're incapacitated where they can't make decisions. That might be a situation where if there's no what we call a healthcare proxy or a healthcare agent, if those estate plan documents don't exist, you might have to petition the probate court to get the authority to make medical decisions for your spouse who cannot make those decisions. A well-designed estate plan, an updated estate plan, can avoid those things with having what we call a healthcare proxy that person you nominate in that healthcare proxy to make those decisions for you. It's quite often that when we make those healthcare proxies, we also make powers of attorney, what we call durable powers of attorney. That's the same thing, kind of similar to what a conservatorship would do, where a person then is able to handle your business affairs as well. So when you have these documents in place, you can avoid probate by just all of a sudden having these operative documents where you're able to conduct business as business needs to be done immediately. And that's what makes them so important.
My husband passed away, and he had a computer, a MacBook Air.
Yes.
And I called Apple and asked them to get the codes
we
and
s-
stuff. And I have the power of attorney, I have the 100% beneficiary, and I have his death certificate.
Yes.
And Apple will not give it to me. They
This.
said
We see this a lot.
We
We see
s-
this a lot. Yeah.
because of HIPAA.
Yes, well, it's. I think HIPAA is an interesting excuse but I think what we're quite often seeing.
So Apple is very, very strict. I helped a woman a couple of weeks ago, a very tragic story. Her 19-year-old son was killed in a car accident on Route 95. And he's 19, he had no estate planning at all. And she just wanted to get into his phone to get his pictures. And so we were trying, where he didn't have assets, we could do something called a voluntary administration, which is under $25,000 and excluding the value of a car. So there's all kinds of criteria for the way you're going to proceed in the probate court. But they wouldn't even accept that. So she had to go through a different probate process, which is more involved, but we did waive her fees. And so these are the things that people, but Apple is very, very strict with that. Mike.
So the ultimate problem that you have is that, at least this is what my understanding of the problem is. The biggest problem is that Apple looks at this and says, your Apple account is not yours. Yeah. It doesn't belong to you. So if it doesn't belong to the person that passed away, then they say that it's not probate property. So it's not something that we could potentially reach through a probate estate, through appointing a personal representative to represent an estate. Right. Yeah. But they look at it and they say, it might be in his name, but they look at it and they say, it was a license. It wasn't his property. So if it's not licensed and it wasn't his property, then they won't give it out to anybody, no matter who they are. Isn't it very counterintuitive? It is. It's problematic. It's very frustrating. And I don't know if Joanne, if you've run into this in practice. So I haven't had to, as a practitioner, I haven't had to be an advocate to a person to really get on the phone with Apple and getting down and dirty with these fights. But that is my understanding, and that's my understanding of their position. Unless Joanne has also had other experience, because I'm sure it's whoever you speak with.
Do you need immediate help with anything?
Do I have to call the court? Well, there's nothing financial on it or anything like that.
Yeah.
It's just that I want to use it, the computer and stuff, and I can't get into a lot of areas because it's in his name, and they'll say, put his password in,
Just go to the Apple
which
store.
I don't
Yeah,
have,
yeah.
so I can't do that.
Do you want to speak to it? Sure. And I know we have another question over here.
Sure. So we are experiencing this now, and the lovely lady in the front said, so those pictures, they're not really mine, and that's true, because you're backing up to their iCloud. So technology, y'all, that's been created is supposed to make our lives easier. It's actually given us a headache. So the one client that I did have, it was actually an iPhone, and we did have to go through probate, even though there were no probate assets. And again, probate assets are assets that have nowhere to go when you die. They're held individually. But I presume you didn't have to go to probate because everything was probably held jointly with right of survivorship with your husband. Yep. That's beautiful. I love hearing that. So what I did do is I had my client appointed personal representative of the estate through a formal, so that there were no questions. We tried to work with Apple, but I had them take their letter of authority, which is when you're appointed a personal representative. That's your golden ticket. That gives you the authority to speak for someone else, okay? Because when someone passes, we're in like a purgatory side, purgatory area when we don't know what's going on. You have to be appointed. You have to have authority to speak for someone else. And then I had them go to the Apple store, and the Apple store helped them. But they needed something legally to be able to get into that computer. So you could try that. And so you'd work with an attorney. I mean, I'm sure that they would assist you as well. But if you go to the court and you file a formal petition, yeah, they won't take a voluntary because that's not a true. Yeah, they won't see it as a true appointment.
One of the things we can try. 'Cause
Yep.
It's a cost-effective process if it can work, but that's there's different processes to do these appointments. Yes.
I didn't do an order of complete settlement because there's no money.
Will they send me to the right department?
I would go to the Apple store in Dedham. They're great at Legacy.
They won't do it.
If you have a letter of authority,
Well, right now, I don't have a letter.
Right.
how about you try a different Apple store after you get the letter of authority?
Where do I go to get the letter of authority?
Yes, and that would be to us. That would be to us. If your husband, you said it's your husband's, right? It was your late husband's, and your late husband was a resident of Norfolk County at the time that he passed. Yes. So so you would come to us. You would come to us, and you would file with us, and you can always come in the door and ask for either one of us. We try to make ourselves very available, but. That is the register. That is Register Colleen Brierley. Yes, the Register of the Norfolk Probate Court. Yes, but so and we can help you because it's a very difficult situation. I mean, dealing with the loss of a loved one is difficult enough. When you have to all of a sudden jump through these hoops, when you have to go through probate, if your estate plan wasn't updated or there's some things that were missed, that's sometimes that's what, even if you have a good estate plan, sometimes you still wind up with us anyway for some of these types of things to try to clean up these additional things that aren't contemplated in an estate plan or can't really necessarily be reached in an estate plan.
I want to say
Sure.
one thing. There are attorneys that do volunteer their time, and they're lawyers of the day at the probate court. And I myself did it recently. And first of all, I thought it was a wonderful experience. But when you go there, you can see if there's a lawyer of the day available and bring the original will and a death certificate with you. Okay? So you have those things with you because they're going to ask you for them so that you can be ready for that. Okay. I just want to go back to what Barbara said, and then I promise we'll go here. So when you, husband and wife, you have no authority to speak for someone, your spouse, even though you're married. According to the federal HIPAA laws, everyone has to have written authorization to speak for someone. So you can't even get blood test results for each other. So just think of that. That's how important that paperwork is. And as Michael also said, we've talked about this before, having a durable power of attorney, again, is a golden ticket, because if you don't have that, then you will, if the person becomes incapacitated, because the durable power of attorney dies with the person, if you become incapacitated and you can no longer speak and nobody has a durable power of attorney for that principal person, no one has authority legally to speak for them. So that's why it's always important to make sure that those, not only you have it, but remember, make sure they're updated, because there can be law changes. Yes?
Besides the healthcare proxy, don't you have to have a HIPAA release form so the person that you appointed as your healthcare proxy?
So a well-drawn healthcare proxy, and not just the ones that you get off of the internet or at Staples. A well-drawn one will have the appropriate HIPAA language in it, and also a well-drawn durable power of attorney will have HIPAA language as well. I know we have a question here.
It's not a question. I have an Apple phone and a Mac computer, and I have a thing from Apple giving my daughter permission to go in there if anything happens to me.
Okay.
They have that from Apple, and it's available.
How did you set that up?
I don't remember, but I have
Okay.
the certificate and everything in my house,
That's an important piece of information. I actually hadn't heard that yet. Yes.
Gives my I had to designate someone. I designated my daughter.
Okay.
My daughter has permission to go into
I
want to make sure everyone heard that. She has designated.
yeah.
She has designated someone with Apple that can speak with Apple in the event she's not able to speak with them, whether it's incapacity or death. So she's not quite certain how it set it up. I'm going to, this afternoon, look through my settings, because it's got to be somewhere in that general information in the settings to see, to put in a person's name, and I'm sure probably a phone number too. So thank you for that. That's great. Thank you for contributing that information. Thank you. Yes.
Just recently, I signed up for an app, Family Tree, a genealogy app.
Yes.
And when I was signing up, I signed up for several reasons. One, I had a sister-in-law that was using it, and so we could work together with it. Two, she told me she could put in that she could license her daughter and her grandson. As I'm single, I did the same thing when I signed up. I did the daughter and the grandson. Therefore, there are two licenses. These people, when I pass away, they can get everything that's on there.
And what's the name of that app again?
It's Family Tree.
Family Tree. And what do you...
Tree Maker, and it's a genealogy.
Genealogy. Okay. So any genealogy research that you've done, the people that you've given the licenses to can access that app.
Yeah, and it's in the settings. You have to go
Yep.
to settings and put it in. The other thing on passwords, I don't leave them on the computer.
Yep.
Computers can be hacked. I keep a little black book, and I've got them that way. I would look around the house, see if he can't have every single password in
Oh,
his
he's
head.
written some down, but I couldn't, he had 4 Apple ID things, and you can only put in 3 to see which one worked before the thing shuts down.
Yeah, that's one of the things that we've been concentrating when we work with clients, when we first meet with them. You know, some of you have been tortured by my estate planning questionnaire, but that's a whole nother page that we have there now. And, you know, the difficult part is some financial institutions make you update them every so often. So what I suggested to my clients is use the same password and then go through the alphabet. A, B, C, D, E, F, G. So, you know, you've got multiple ways that you can change it with that. So thank you for that information. Yes.
If you go into your password and security, it's called Legacy Contact.
Legacy contact. Apple, make sure you put in your legacy contact, because that will be the person that will be able to speak for you. Okay, yes.
The same thing happens with, I have my daughter, I'm a widow. So if I die, she can't use my, she can't get
Right,
anything,
right.
Same thing?
Yep. So if you can do it yourself, that's great, but otherwise have a child or a neighbor or someone fill in that legacy contact for you.
Well, I'm glad we came because we're learning so much from you guys. I think this is the opposite. This is awesome. Yeah. Any other questions or? Yeah. Oh, yes, ma'am. Yeah.
I own my own home.
What? 1 second, please. I'll come down there.
I own my own home, but it was joint with my husband, and he's passed away. So if I were to sell it, is there a problem with probate or anything?
No. No, if you owned it joint with your husband, upon his date of death, his 50% undivided interest immediately went to you. Okay? Yeah.
Call that by operation of law. So
Yes.
it's
Rights of survivorship.
I have a follow-up on that. If the survivor took,
So it's a married couple.
Yes.
One person dies. The survivor took the decedent's name off the deed after she died. Does that change anything?
Yeah.
Thank God. Okay.
It's the legal effect. The legal effect of the passing with what they, yes, the legal effect of from the passing and what they already had together. That is some of the benefits of owning property jointly. There's different types of joint property ownership. Is like the lowest level is what they call tenants in common. Quite often, people hold property jointly with rights of survivorship, and then there's the additional tenancy of marriage, where people own as tenants by the entirety. And those two top rungs of tenants by the entirety and joint tenancy with rights of survivorship both operate very similarly in terms of when one person passes, the rest of the property automatically rolls over to the title and interest of the survivor.
But in terms of the basis and stuff.
I guess you answered my question, but do you have to have your husband's death certificate to sell the house?
Usually, I would think. Good question. Yes. Yeah. Usually, anyone that's helping with a recording transaction, we're what's called a record notice state when it comes to real property, real estate. When it comes to real estate, we're what's called a record notice state. So, what is on record with the Registry of Deeds does matter. So at a point when something like that would happen, they would want to record the death certificate so that the recording shows that the property, by operation of law, has passed to that survivor.
Now, if my lawyer had sent in something to probate or wherever she sent it, stating that he passed away, is that all set, or?
It most likely is all set, but it's something that you always want to confirm, and any decent practitioner can always make confirmations to you in writing. Can you give me an update on my estate plan? Can you give me advice as what I should do and why? Never be afraid to ask a practitioner about a writing.
Registry of Deeds.
Certainly. Registry of Deeds, you'd want to know that things are recorded properly in the Registry of Deeds as it relates to the real property.
Sent something in.
Okay.
I think I had to pay a fee.
Sure, a recording fee. Sure.
Okay.
You worry about these little.
I know, right when you're going to sleep, right?
Yep.
And I'm very happy that you brought that up, because some people will say, my husband has died. Do I need to change my deed? Do I need to update my deed? And you do not. How it gets updated is by recording that death certificate. You don't need to draft and record a new deed. So if anyone tells you that, that's not the way it goes. You put the death certificate on record, and like Michael said, fundamentally through the operation of law, your husband's 50% undivided interest immediately went to you. Okay? I know there's a question down back, so let me grab that one. She's been waiting patiently. You good now? Oh, good. Oh. Excuse me.
I have a question about death certificates. You frequently talk about death certificates, and I have found that there's quite a difference between an original and a copy of a death certificate. And I think when you deal with insurance companies and even medical, people require an original, and sometimes it's difficult to do things. You think, well, I've got a death certificate, I just make a couple of copies of it and use that, and they won't accept it. I'd just like you to respond to that type of thing.
Do you want me? I can take that one. So there's only one original death certificate, and that's the certificate that's filed, rather signed by the doctor that literally calls the death. That's the original, and that gets filed with Vital Statistics in Boston for the Commonwealth of Massachusetts. Then what happens is it goes to the clerk's office of the town or the city where the person died. The clerk now is the person that's in charge of that record, okay? Just like they're in charge of the records in the probate court. The clerk is in charge of that death certificate. Then what they do is they create what's called certified copies. Okay, but that is what we see as an original. You have to feel and see if the seal is on it. It needs to have a seal. You can't just run it through the photocopier. It has to be certified by the clerk. Okay, so when you're using any death certificates, you need to make sure that they're certified from the town clerk's office. And if you know where someone has passed, you can order one. They're generally $12 to $15, and Walpole turns them around very quickly for us.
I was advised to order multiple at the initial request.
At the funeral home?
Yes. And
Usually the funeral home will order multiples, either 5 or 10 of the certified copies for you. And that's very helpful, because I do know when someone's deceased and they come to our office, we immediately ask for 3, because one's going to be filed with their records, and then we're going to need an original 1 or 2 for other things that we're doing, filing, putting it on record if they own real estate, and an estate tax affidavit that goes along if it's something separate. So I generally ask for 3 originals, but they're certified copies. Yes.
If a person dies in the military, let's say in Japan, like my husband did, do they automatically do all this in Massachusetts? Like he's from Massachusetts.
Yeah, it's a good question. It's quite often actually that people pass away while they're abroad, whether it's in military service or on vacation. Unfortunate way to go on vacation, Max. But it's something that does happen quite often, and the question ends up always being, where were they domiciled? And where they're domiciled, that's where they live. That's where they call home. Where they go back to when they're away. Right. So where a probate proceeding takes place is dependent upon where the person that passed away was domiciled, where they lived. Or they could sometimes live somewhere else but hold property. It would usually be in that instant, it would be real estate in the Commonwealth. So there could be so I guess the question the answer to the question is, it just depends on the facts. As in terms of where a person was domiciled or where they held property. So if this individual had passed away while they were in the military, but they always called Massachusetts home, particularly Norfolk County home, and they had probate property here that they left, property that was only in their own name, that needed to still go somewhere, then there would be a probate proceeding in our court in order to determine whether the person passed away with a will. And if they did pass away with a will, then the property would go in accordance with that will. Or if they did not pass away with a will, we would do a probate proceeding to determine their heirs. And their heirs would be the ones who were entitled to that property.
Domicile was California at the time.
Okay.
Comes from Massachusetts.
Mm-hmm.
And we had to make out wills before we could even go overseas.
Okay.
The military, you can't go.
Yes, you are right. They'll make you make a will. Yes, they will. Very true. But, and the other instance would be if he was domiciled in California, but he left a home, he had rental property, or, income producing property that he rented out while he lived in California. That would potentially require a probate proceeding in Norfolk County as well to take care of that property, to determine where that property goes.
Yeah.
Thank you.
You're welcome.
One extra little point on domicile. Domicile, we usually look at where someone lived because generally most people, that's where they are domiciled. However, we do look at the tax returns that you file with the IRS and what's on your driver's license. So if someone's on vacation, out of state, but where they're domiciled, that's where we file the probate, because the probate court has jurisdiction over people in that county. Anything else? Any other questions?
I just have a general question. Why is family court part of probate?
That's an excellent question.
Don't get him going on that.
That's an excellent question.
So Michael thinks that they should be 2 separate courts. And but we do have a juvenile court in our state, and then probate and family court, which handles both a lot, like I had mentioned when I started, a lot of subject matter. But I feel that we're up for the challenge. So, but I'll let Mike have his moment here.
Well, it's an excellent question, and I think my take on it that the Register has mentioned is more because of not where we were 100 years ago, but where we are now. There's a lot more of a need and a lot more involvement in the probate court. And there are things that have contributed to that. The opioid crisis that has gripped so many areas of the country. We have not been saved from that in any way, shape, or form in Massachusetts or in Norfolk County. So when we have many, many more people, it feels like all the time, and sometimes the numbers show this and sometimes they don't. But I think in general, our numbers continuously tick upward every year in terms of the amount of people. I mean, there's more people in the world every day, right? There's more people in the world. So there's more people in the world. There's more people that have problems. There's more people that need court intervention or court processes to conduct business as business needs to be done. So from that end, we do have a lot more. I mean, you hear about the divorce rate going higher all the time. You hear about the opioid epidemic, which is just so difficult on people who, grandparents who have already raised their children and feel like they've done their job, paid their dues, and then the next thing you know, you're still caring for that parent because they've been wrapped up in this opioid crisis, and now you're taking care of your child and your child's child. Very, very difficult, but it's something that involves our office, involves our court, and we see it all day. And it does tend to overwhelm resources at times. It just makes it very difficult.
Yeah. And at our court, on every Tuesday, we have a guardianship clinic, and we have, as was mentioned earlier, Lawyer of the Day program that we're constantly trying to build up, because that is an invaluable resource to the public, people coming in crisis, looking for guidance. But we also have brought in an agency called Grandparents Raising Grandchildren. Has anybody heard of that agency? So they're at our court now every single Tuesday. And they are a great resource. They sit down with people and refer people to services. So if a kid's in foster care, and I have been a foster mom and I have adopted 3 children through fostering, so I know and have worked in the juvenile court for years and years, but people don't realize that when you're in foster care, you get all these services. You get kids can get state college tuition paid for. They automatically qualify for Mass Health, different services with educational advocates. Transportation, if a kid has to leave their school district, the state is obligated to transport that child. But grandparents step in, and they're not connected to any of these services. So that's what Grandparents Raising Grandchildren, their mission is to do, to connect families, kinship. And it doesn't have to be a grandparent. It could be an aunt, an uncle, or even a neighbor, and connect people with those great services that are out there for kids. So we have that at our court. If anybody wants more information about that, come down to the court on a Tuesday. We'd love to see all of you. Or you could just, do people know about our virtual registry? You can hop on a Zoom and talk to any of our clerks, any of us, Mike or I, and we have 2 other assistant registers. Since I've been in office, I've been building up the registry, and Mike and I strongly advocate to get more hands on deck. I think I've been able to hire, in my conversations, battles with the administrative office, about, 18 new employees, and that is all about processing paperwork. I've been able to get 2 assistant registers. One's an attorney, one has come from probation with a DCF background. So I'm really trying to build up the team. I would like to be elected again, but if not, my goal is always to make Norfolk County the best registry in Massachusetts, so that when I do leave there, that, it's in great shape, it's organized, and that all these services are tied into for the public of Norfolk County. So.
Just to verify that everything looked proper and so forth, and it was registered properly.
Sure.
Is that just a glitch in the search?
So you're referring to the Registry of Deeds for property. So the Registry of Deeds houses all of the public records of people that own property. So if you're registered land, that's a different side than unregistered, or also called recorded land. So sometimes, could I ask your last name? Does it have an apostrophe or anything in it? No? Okay. Sometimes if there's an apostrophe, sometimes it'll be there, sometimes it won't. So when you
I did search in the proper
grantor, grantee indexes, and you couldn't find it by your name, it could be possible.
by the address. I had to do it by book and pay.
It could be possible that it could have been spelt incorrectly. Maybe the letters were inverted, which does occasionally happen. But if you found it by book and page, then you know that it's on there. And then you can look to see how the grantor and the grantee clauses.
They were correct. And I looked at the view of the actual document as well, and everything was in there correctly, but I don't know why it was difficult to search for it, because it should come up any of the three ways, shouldn't it?
It should. Yeah, it should.
I don't know if it's just my property or.
No, we're on the Registry of Deeds all the time, so that it usually works pretty well. So at that particular.
That I should investigate?
No, I don't think so. No, you're fine. It's on public record, so you're fine. Yeah, as long as you know it's there. Yes.
If you do a will, like we do wills, but we get to the VA,
Okay.
but I've never turned in the papers, like, I mean, we get the wills, it's in Norfolk, but we never did the other assets that we have, which is a.
Okay, so that's called funding a trust or making sure you have a joint owner on it so that, again, it has somewhere to go when you die. Is that what you're referring to?
Well, I'm just thinking, like, we left everything to our two kids. If everything's
Through your will, everything goes to your children. So while you're alive, you should be holding everything jointly. Joint bank accounts, CDs, investment accounts. If it's a CD, make sure your beneficiary is named. If it's a life insurance policy, make sure your beneficiary of the life insurance policy. So you've done that whole exercise. Okay.
I'm just thinking, like, I didn't do anything with our cars.
So cars, you can own them together. You can't own an automobile. You can't register an automobile in the name of a trust. So you can own them together. But actually, this is a little tidbit. The one thing that the Registry of Motor Vehicle does to make things easy is that if there's a surviving spouse and you go to the Registry of Motor Vehicles and they only owned it in their name, there's one form that you fill out and you bring the death certificate, they will transfer it over to your name without a will. That's only between spouses in Massachusetts. Okay? And yes.
My husband had a car with his name only.
Yep.
So I had to go to the registry and get it transferred to my name.
Yes.
And I had to go get an inspection sticker. So then I transferred the car over to my son.
Yep.
And he got pulled over by the state police because he didn't have an inspection. He had the inspection sticker I got. The state police said since ownership changed, he has to go and get another state inspection.
And it hadn't expired? Wow. How did they even know to pull him over for that? Oh, maybe there was another reason.
Don't answer.
Yeah. Yeah.
And the cop said, that's fine, but you have to go and get an inspection. They had signs on it.
Okay. Well,
So I had to double pay for the car.
yeah. Well, they did change that on the inspection stickers that you have to stick with your month. And even if you're like a 10 and you don't get it until 12, you have to renew again the next year with a 10 in the month of October. So they did do that. Are there any other questions on what the probate court facilitates? Do you have a better understanding of how they literally work with people that just come up to the clerk's office, the desk, and ask questions? I've seen it. There's lines and lines of people, and they just continuously help, and it's always with a smile, I've seen.
So your question raises like something that's so important to me, like that your experience with that whole mess, that the registry now, our goal is to simplify things for people and make a day at the probate court. I wouldn't call it a pleasant day ever in anybody's life, but we are trying to help people. I mean, to our staff, and Mike and I, we view ourselves as public servants, and we truly are honored to be in these offices, and we take it very seriously. So if anybody, I mentioned the Zoom virtual registry. You just have to Google search Norfolk County Virtual Registry, and the Zoom link will come up, and you can go on there right on your phone. And I also wanted to say I've started with the trial court and Chief Justice Casey, who's the head of, our boss, at the public libraries, and it's in Norwood right now. I'm going to try to get it all over to every 28 cities and towns in Norfolk County. But you can go into your public library, the one in Norwood, and there's 2 rooms designated with computers that you can access the court. So it's right up on the 3rd floor at the Morrow Memorial Library. And it's also in Quincy and Milton and Randolph at this point. And I need to get it out, coming down Route 109 all the way down to Bellingham. Norfolk County goes to Cohasset, Brookline. So that's a big project. People still don't have internet. People don't have computers. So you can do a Zoom hearing with the judge on that computer. People who we deal with a lot of domestic violence in our court, they can go there for privacy, not have to face their alleged abuser, and just be safe at the library too. So, yes. No, we're in Canton. Yep, right up University Ave. You didn't know? Oh, yeah. I wish we were. I love those old courthouses. They're so pretty over there. And we're. You go up University Ave and at the Granger, is that what the store is? You take a right there, and we're in an industrial park right after that new golf place that they're building. So 35 Shawmut Road in Canton. Yeah. So, yes. Yeah. Yeah. Yeah.
Industrial park.
A little bit more about the probate process.
Oh, sure. Yeah. I'm going to give that to you.
They were above the Norfolk County Registry. The probate court was above the Norfolk County Registry of Deeds on High Street, which is across from the Superior Court, but they grew out of the space, so now they're in an industrial park. Yeah, but it's a very nice court. It's very well set up, and I'd also like to say that they do a wonderful job. We deal with a lot of probate courts through Massachusetts, and Norfolk keeps everything moving along nicely for us. Yes.
So I just, sorry. We covered a lot of topics, but in terms of probate, the process, so the person has a will, they've designated a personal representative, used to be called executor. So we file it with probate court, and you validate the will, and you contact heirs, concerned parties. I've seen things published in newspapers. Okay, and is there anything else, and how long, if everything is simple and straightforward, how long does this whole process take?
So there are 3 types of filings with the probate court. There's a formal, an informal, and a voluntary. Let's start with the voluntary. That's like the quickie one. If you have one specific thing that had nowhere to go, this happens a lot when we sell our decedents' homes and their homeowners insurance premium was overpaid because the policy didn't expire, and that comes back in the name of, the estate of Alice Smith. So sometimes we need to cash some checks. So we'll file what's called a voluntary in order to have the person that's named in the will, again, it's a personal representative, formerly called the executor or the executrix, they now have the power to do that, but to only do that 1, 2, or 3 actions. And it also has to be under the amount of $25,000. You can also use a vehicle. If your spouse is no longer alive and you can't use that quickie little RMV route, you can also transfer a vehicle, doesn't matter the dollar value on it, by way of an involuntary. Then we have an informal and a formal. I'm going to talk about the formal because as a conveyancing attorney, we always use a formal when we're conveying real estate because we need to make sure we know who the heirs at law are because we don't want the buyer of the property to have someone knocking on the door and say, oh, Auntie Susie, she's my relative and I wasn't told about that she died and I should have gotten money when this got sold. So we do a formal because the will has been proven and allowed by the court. Now we can take it and there's a power of sale in there for that personal representative to sell that property. But we also have the court say, these are who the heirs at law are. Remember, you've heard it a couple times today. Their job is to protect the heirs at law and make sure they get what they're supposed to get from the estate. The informal, I generally use it if there's no real estate involved. If it's in a trust, remember it has somewhere to go. We're only dealing with real estate that was owned individually. Informal is used if the assets, probate assets, are over $25,000. Okay, so when you ask what the next step is, it depends on what we're doing, what type of proceeding we're doing. If it's a formal, you're going to have to file an inventory 90 days after being appointed, and that's when you're the fiduciary of the estate. You're supposed to be taking care of those heirs. You're going to file an inventory with the court that says Auntie Susie owned a house, she had some gold bars in her safe deposit box, and she's got some significant jewelry. You have to report that to the court because the court wants to know what's going on. Okay, and then after that, you administer the estate, you process everything, you do your disbursement, you pay all the bills, and then you have to close out that account for a formal. Okay, so you get an order, you file for a petition for the approval of the first and final count, money that came in, money that went out, and then zero balance at the end. They give it the blessing, and then you're done with your job because we get an order of complete settlement. So it depends on what's going on. Generally, a probate estate is open anywhere from 18 to 24 months. You cannot close it within 1 year from the date of death because creditors have a right to file a claim within that probate docket up to 1 year from the date of death. So there's a lot of timing, there's a lot of statutory law that's involved in it. Do you want to add?
Sure. That's, I guess, part of the reason why it's so important to have an appropriate estate plan is because of some of these issues, right? Because there are creditors out there sometimes that can come after property that is probate property, the property that was solely in a person's name upon their passing. There's a lot of things that an appropriate estate plan can do that can protect these assets so they go where you want them to go. With respect to what Joanne has outlined in terms of these different processes, these voluntary statements, informal probate proceedings, and formal probate proceedings, they have some different legal effects, but the basic idea remains the same through all of them. And that is the basic idea is to, when a person passes, if a probate proceeding is necessary, in other words, the appointment of a personal representative, a fiduciary called a personal representative, needs to get appointed to administer this property to where it needs to go, either by will or by who a person's heirs are. These processes are all designed to do that, and what process makes the most sense is what a practitioner can guide you on based on what the assets are, whether there is real estate involved, or if it's rather just an insurance policy, with no beneficiary designation. These processes are all available, and a good practitioner can guide you on what process makes the most sense to address the nature of the property that's involved. With respect to the formal process or publishing in the newspaper, something that you see all the time, both informal and formal processes both require publication. And publication is just designed for any probate proceeding to give notice to the world. One of the biggest things that we can do is determine heirs in the event that somebody wants to object to a will. The heirs have what we call standing. They have the right, because they have a vested interest, to say this wasn't a validly executed will. These signatures aren't correct. This was a forgery, whatever the case may be. There was undue influence, something like that. It was signed under duress. That's part of the reason why we determine who heirs are, or we require a notice to heirs in the event that a person does have a good valid will. Heirs have an opportunity to come and potentially contest a will. Quite often, heirs are similar to the persons that receive in a will, but you can kind of change how they receive it. You can change the percentages in which they receive certain things. So these are all reasons why estate plans are very, very important. I didn't really have anything else to add, but any other questions? Yes.
What is the difference between an executor and a fiduciary?
Nothing. An executor is a type of fiduciary. Fiduciary is a general term. So a fiduciary, again, can be very different types of hats, but they're all fiduciary hats. A trustee wears a fiduciary hat. A personal representative of an estate is a fiduciary. The idea is a fiduciary acts on behalf of and for the benefit of another or another class of individuals.
Very high level of trust.
Yes. Yes.
What the connotation there is.
Yes. So different types of fiduciaries, but a person that's a healthcare proxy, that's what we call a healthcare agent that's nominated as a healthcare proxy, that's a fiduciary. A person that's nominated as what we call an attorney in fact under a durable power of an attorney. The person that you've given that power of attorney to act in your best interest is a fiduciary. So these are all types of fiduciaries. The old laws for the probate proceedings, for probating wills and estates, we used to have these different names called executors or executrix, because it was gender identified between executor, executrix. We would call them that was when somebody passed away with a will. When somebody passed away without a will under the old law, it was just called administrator, administratrix. But that was the difference in the designations there. Now everybody's called a personal representative, and that is whether you're a male or female, cat or dog, or died with or without a will.
You want to talk about that later?
Absolutely.
The animal that we see?
What's that?
Animal cases that we
Oh
see?
yes,
Yeah,
that's something that we deal with quite often too. We do have animal trusts. We have it's quite often this, you know. Oh yes, I will get the will that says I leave everything for the care and maintenance of my cat. You know, we do see that. We do see that. These are things that people can do. Yep.
Does that ever get contested?
I've never seen anybody contest it. Nobody's ever really wanted to combat the cat that I remember. You know, the cat usually lawyers up pretty quickly. That's right. That's right.
I gotta
That's
get
right.
him back to the court. So, here, did you want?
Yeah.
Do you want to wrap up?
Sure. I guess I'll just say one final thing with respect to that handout. The handout's meant to be just a very, very basic guide, right? And it's just to kind of show you and highlight some of the proceedings that, as the Register had mentioned, that's not even close to all the areas of law that we deal with and the subject matter that we deal with at the Probate and Family Court. But we felt that these are quite often questions that people have when we do these types of things. We have these question and answers. The handout is really kind of one of the highlights, I guess, that isn't articulated on the handout, but you can kind of see our office, the Probate and Family Court, handles situations for both. There's probate considerations to deal with both while you're living and when you pass. The living part has always been a very, very concerning, and to me, one of the most practical things you can do. When you see this information about guardianships and conservatorships, those are proceedings that occur while a person's still alive but needs help, right? They have unmet needs, or they have some clinically diagnosed condition that impairs them, that blocks them from making good, solid, informed decisions, whether it's about their health or it's about their business affairs. So that's what these guardianships and conservatorships are designed to do, these appointment proceedings. But that usually happens when you don't have a good estate plan. So it's important to have a good estate plan to avoid probate considerations while you're still living. You know, if you have a spouse and you both get in that car accident and you're the person that is okay, and it's your spouse that is sitting in a hospital that can't make decisions, the last thing you want to have to do is to go to the probate court. to have to conduct it is a lawsuit, in effect. A guardianship, a conservatorship, these are lawsuits. You have to file a petition with the court with medical evidence and documentation that shows that this person has that unmet need, has that clinical condition that avoids that stops them from being able to make good, informed, sound decisions. You have to give notice to them. They have to get served by a third disinterested person. Other family members might have to get served and given notice. You have to schedule a hearing and then go in front of a judge and explain this to a judge and tell them why you need this appointment. That's headaches and concerns that you don't need, anxiety that you don't need. That's what good estate planning can avoid. So that's why these things, healthcare proxies, durable power of attorneys, they're so important. They're so powerful while you're living. The probate property aspect of wills and things like that, they are very important, but those are things that happen once you pass. And as much as that's important, nothing could be more important than while you're living and knowing that people that you're trying to care for and people that are trying to care for you, your loved ones, have the things they need. It helps you sleep at night better when you go on a trip, when you take a flight, anything. It just that is a feeling of contentment that you've lined things up the way you feel like you need them to have lined up so that people can do the things that they need to do to act in your interest and the other family's interest, so that you're not skipping a beat and you don't have to worry about contested proceedings. A brother comes in and say, well, that's the spouse, but they never had their best interest at heart. These are concerning things that you don't want to have to worry about. And if you do a good estate plan, you see a good practitioner, you're going to avoid a lot of these problems.
For my position? Sure. I don't think it's in the statute. The Register of Probate is defined and authorized or created by Mass General Law 217. And so it does not require that. And there are other registers across the state that are not attorneys. I have been an attorney since, I don't want to tell you, 1996. So, yeah. Yes?
What's specifically to be done, like palliative care only, et cetera, et cetera?
Yeah.
And they honor that too.
Yes.
Because it's in writing.
Yes.
We don't like gray. We
Yes.
like black and white.
Correct.
In writing. Okay. Well, thank you so much, Colleen and Michael.
Great question.
Yeah. Thank you very much. And I appreciate everyone coming in today, and those questions are helpful. And if there's any follow-up, just let me know. Thank you so much. Have a great afternoon.